Thank you all for joining us today for the installment of Becoming Fierce in the Law, in the Practice of Law Ethics Edition. I'd like to introduce you to Assistant Secretary Tavares A. Walker, who will be giving us today's presentation. If you have any questions, please feel free to use the Q&A button. Also, I will be monitoring the chat. If you have any questions, you can put it in chat. Thank you, and take it away, Assistant Secretary.
Well, that's funny. The phone never rings. Well, good morning. Well, good afternoon to everyone. Thank you for joining us for this presentation. And I am hoping that you are collecting your CLE hours so you can get to your 12.5 by the end of the year. So this is a 1-hour session on ethics in the practice of law. And I have prepared a brief slideshow presentation to guide our conversation. As Ms. Dickerson indicated, please feel free to stop us or ask questions as you go, because I am no way an expert. So I just did a lot of research and put together some talking points of some common pitfalls that lawyers encounter. So the next slide is just a little bit about who I am. I currently serve in a dual role for the department, which is the Workforce Commission, which is formerly the Department of Labor, and I serve in a legal role, and I head up the Office of Workforce Development. The Office of Workforce Development is the operation of the state that develops and trains and builds up the workforce, and it is responsible for about $300 million in federal grant money. I spent the bulk of my career at Southern University in various capacities. My last capacity before leaving, I was the Associate General Counsel for the system. So with that being said, we're going to jump right into the presentation. And it's entitled Common Ethics Traps. And we're going to go over about 8 to 10 scenarios that is common that lawyers find themselves in an ethical trap. What I did was I didn't focus heavily on Louisiana because I didn't know if we were going to have an audience that was from other states. So what I did was I based the presentation around the ABA model rules just so that we can kind of keep it nationally versus Louisiana. But I will tell you, most of the rules, 95% of the rules are identical. They're just adopted by Louisiana or whatever state. The first thing we could talk about is some common terms to know. And I will be the first to tell you, I swiped this right from the Louisiana Disciplinary Board about issues that commonly come up that lawyers are commonly disciplined for. Commingling, that's the act of putting together your funds with client funds and perhaps spending those things that would breach the attorney's fiduciary responsibility. And they define fiduciary is defined as one often in a position of authority who obligates himself to act on behalf of another or manage money or property and assumes the duty to act in good faith with care, candor, loyalty in fulfilling those obligations. Obviously, as an attorney, we all have a financial fiduciary responsibility, but also a legal fiduciary responsibility in that we do manage clients' property, money, and whatever legal issue that they hire us for. The next issue that comes up because of the technology, and we're going to talk about that a little bit, is this idea of confidentiality. Where does it start? Where does it stop? What guarantees that you have to provide to your client? And how do you make sure you maintain that relationship between the lawyer and client that guarantees that the information you share will be treated as private and cannot be divulged to third party without the express authorization or consent of the client? Neglect and lack of communication. We probably all are guilty of that at some point, but it may have not risen to the level of a complaint. But a large amount of the complaints, attorneys must respond to and remain in reasonable contact. The key word is reasonable contact with their clients, keeping them informed of each and every step of the litigation or whatever matter, and fully explaining to them the crucial aspects of the case. Again, the operative word is reasonable contact with the clients. So that definition, obviously, it is a defining case law in issues that has risen to the disciplinary board, but obviously clients have a different idea as to what reasonable communication means, because each one of them expect you to respond to their emails immediately. Solicitation. Attorneys may not be misleading, fraudulent, or deceptive in their advertising. For instance, lawyers may not use statistics or client testimonies and refrain from guaranteeing specific outcomes for cases. The weirdest thing that I saw, I was riding down Interstate 10, and not to say that it's unethical, it's weird that I saw it. And I saw a certain lawyer standing on top of a 18-wheeler filming a commercial. And I was like, oh my God, they still do that? But nonetheless, you can't be misleading or fraudulent or deceptive. And malpractice, obviously, once someone files a claim, whether or not you have coverage or whether or not your behavior amounts to malpractice, these claims are very difficult to prove. Lawyers may be sued if no reasonable attorney would have made the same error. And again, no reasonable attorney would have made those same errors. So that reasonable standard coming into play again. I like to put this up here, and again, I swiped this from the State Bar Association. Professionalism concerns the knowledge and skill of the law, faithfully employed in the service of a client or public good, and entails what is more broadly expected of attorneys. It includes courses on the duties of attorneys to the judicial system, court, public clients, and other attorneys, attorney competency, and pro bono obligation. That is what we call the professionalism standard that is laid out in regulation. However, legal ethics is a term used to describe a code of conduct governing proper professional behavior, which establishes the nature of obligation owed to individuals and to society. Legal ethics set forth the standard of conduct required of an attorney. Professionalism includes what is more broadly expected. And again, I pulled that directly from Section 1, Rule 3C of the Rules for Continuing Legal Education as amended by the Louisiana Supreme Court back in 1997. Generally speaking, ethics rules tell us what we cannot do, and professionalism deals with what we should do. And Louisiana, just like every other state, has an illustrious rule book containing what we must do and what we can't do as attorneys. And obviously our professional code tells us what we should do. So the first thing I will be labeled as the ethics trap that we talked about, stumbling into a lawyer-client relationship. This one I find very, very interesting, and I was able to pull a case. It's a federal case, actually, from Arizona, and this person kind of stumbled into representing this person. And anyone who works in-house can relate to this, wherein this attorney was representing the company Motorola in a dispute. However, an employee was the main point of contact, and the attorney had reached out to the employee, and the employee had participated in a deposition where the attorney was present. And again, the attorney was hired to represent the company, and this employee was the main point of contact. So Douglas was a Phoenix, Mr. Irish was a Phoenix attorney representing Motorola. However, employee Mr. Dean Corley managed a shop for Motorola, believed that Irish and his firm represented him. When Motorola threatened to sue Corley because he was doing some things with a prospective buyer outside of a non-compete agreement, he moved to disqualify the law firm and Mr. Irish's representation. And in this case, the court ruled that a magistrate judge ruled that Corley had shared confidential information with Irish in the belief he was Corley's lawyer and that Irish had a conflict of interest. And so the reason why I put this case up here, because the court looked at what was Mr. Corley's intent when he engaged with the lawyer. And the court said, well, we're really going to look at, he shared information, confidential information that he would not have otherwise shared with this lawyer, not just Motorola's information, but he shared his own potential business operation, his business aspirations, and some things that were shared under the belief that Mr. Irish represented him. Coming from someone who has worked in House counsel at Southern, we always had those issues when employees were named defendants in addition to the institution, that the employees somehow believed that we represented them as well. And in some cases we did, but what we did to prevent that, we executed acknowledgement documents saying, hey, we represent you in so much as only for your employment purposes and nothing else. That's how we kind of warded against blurring the lines of whether or not we personally represented the individual, because we only represented you in your position in employment with the institution. And should that ever end or our interests contravene, then we don't personally represent you. But nonetheless, the case is cited there. It's a federal case. And I would just say, as an ethical obligation, you have to be very, very careful about stumbling into lawyer-client relationships with folks. And to me, this case says it all hinges upon what the individual thought was the relationship between the lawyer and the potential client and what information was shared. The next thing, virtually everyone is a potential client. If a lawyer isn't careful, someone may inadvertently become an actual client or think he is the actual client and often have grave consequences. Again, as I mentioned to you, I looked at the ABA model rules, and in section 14, it said the relationship is formed when a person manifests an intent that a lawyer provided legal services and the lawyer either A, manifests the consents by doing something in addition, or B, fails to manifest lack of consent and knows or reasonably should have known that the person reasonably relied on a lawyer to provide services. In other words, if a person asks a legal question and a lawyer answers or says he or she will look into it, a lawyer-client relationship may have resulted. And again, I put a federal case in there where it outlined, it says that there's no need to sign a formal agreement, or shake hands, discuss rates, or even send an engagement letter. A person becomes a client even inadvertently if it triggers all the obligations that we just talked about in the model rules. It further, the ABA rule 1.10, an inadvertent client relationship also imputes to the law firm, not just the attorney. And that's just a case up there that was cited on the ABA website that talked about whether or not that lawyer actually avoided inadvertent clients. And this lawyer in particular faced a malpractice claim, and the court upheld a $650,000 judgment out in Minnesota. The internet. I've seen this a whole lot. It seems that new attorneys in particular, the first thing they do is go to the internet to advertise. Obviously, for our Louisiana lawyers, we know we have very, very specific rules about advertising, but I think the internet is kind of not regulated as much or hard to regulate. So some 30 years ago in Bates versus Arizona, that's suing the state bar of Arizona, the United States Supreme Court laid out some fundamental acceptable lawyer advertising. Again, it may not be false, deceptive, or misleading. From these three simple ideas, all 50 states, as I just mentioned, crafted some rules. Just some tips that came from that case. Obviously, you must comply with whatever state, home state jurisdiction or regulation that you might have. Obviously, for us Louisiana lawyers, we revert to the Louisiana State Bar Association. It's always a great idea whenever you advertise on Facebook, Instagram, websites include whatever disclaimer that the state requires. It's also a good idea to put in an ad and say these exact same words, that this ad does not create an attorney-client relationship or protect any confidential information until a written agreement is signed. Again, that's another disclaimer. And obviously, you also should put in there a note of disclaimer that this ad should be voided if it's prohibited by law or runs afoul of any state rules. And that's just some general principles, some ethical guidelines, some basics that you should consider when you are advertising on the internet. This one is always interesting. My boss made me do it. And I took the names out of this one because it was a familiar attorney, but I'll just read it. When Attorney A started working as a managing associate of AA law firm in Louisiana, he was in for unpleasant surprise. Attorney A discovered that the firm was inflating government billing for HUD. When he asked his boss told him the practice was legal and ethical. He did nothing else. He just continued to practice. And obviously, I put up there a wrong answer. The Office of Disciplinary Counsel, once the federal government found out, informed Attorney A that the firm failed to keep sufficient records for recording fees charged and failed to track client fees relating to those cases. And in addition to that, the ODC wanted to reprimand Attorney A, but Attorney A had the good understanding that he acknowledged he had a duty to tell his clients that the bills were inflated. He also had a duty to report unethical behavior with other lawyers in his office, and that my boss made me do it was not an excuse. So even if you work for an attorney who's signing your paycheck, which can put you in a precarious situation, you are under an obligation by the ABA model rules and Louisiana rules. You have to report unethical conduct to the bar, and you also have a duty to notify your client if something unethical was done. And in this case, HUD was the client. And I kind of overtalk myself. It says report even if it hurts you, right? It's kind of hard reporting your boss. But ABA Model Rule 5.2a says a lawyer is bound by the ethical rules, notwithstanding that the lawyer acted at the direction of another person. The single exception to this rule is that when the lawyer acts in accordance with a supervisor's law is a reasonable resolution, arguably a question of professional duty. It's not enough of a subordinate lawyer to refuse to comply with unethical directives from supervisors. The lawyer is also bound by Rule 8.3 to report the supervisor to the appropriate disciplinary agency. Obviously, you would do this with caution and care for the most substantial ethical violation, but nonetheless, I put it out there because there is a published Louisiana ethical opinion that basically says a lawyer is obligated to promptly report to the Office of Disciplinary Counsel knowledge of misconduct by another lawyer where the conduct raises a question as to the lawyer's, and this is where they say it is mandatory, that the lawyer's honesty, trustworthy, or fitness as a lawyer, and where the supporting evidence is such that a reasonable lawyer, under the circumstances, would form a firm belief that the conduct in question had more likely occurred than not. So that places the duty upon the attorney who witnessed the bad behavior, who knew about the bad behavior. Not only do you have to inform your clients, Louisiana says you have to inform the bar, and not the bar, but the Office of Disciplinary Counsel. So you could peruse that opinion out there if you like, but nonetheless, it is a published opinion outlining, or as we would say, promulgating this into regulation in Louisiana. Law firm breakups. This one talks about the duty and ethical obligation that all attorneys have when they split up. This case involves a Chicago law firm. It triggered a 14-year legal battle, and the primary issue in the case is whether the departing lawyers breached their fiduciary duties to their former employer by using confidential information to help arrange financing for their new venture and by soliciting one of the firm clients. In this case, a federal appellate court noted that the lawyers may use the list of clients expected to leave the firm to help obtain financing for the new practice. This case hinges on the clients were leaving anyway. So the departing attorneys could have engaged with those clients that were leaving on their own volition. It says the evidence leads to a reasonable inference that the partners actually solicited the Allstate business, secured a commitment from Allstate for future business, and obtained financing based on that commitment, not a mere expectation. So this case talks about when clients want to stay with the firm that's breaking up, or when clients make that voluntary decision to move on, and talk about whether or not it's okay to somehow solicit future business from them. And we go on to what I just said, it defers to the client wishes. Courts will always look to, when there's an ethical issue, what did the client want? When a law firm breaks up, things can be very messy. The ABA equates it to a marital dispute, but who gets the custody of the clients? Rule 1.16 of the ABA model rules give the client the unfettered right to choose whether to stay with the original firm or to move on with the departing lawyer. The departing lawyer cannot make that decision. I want to be clear on that. The ethical obligation, the departing lawyer cannot make that decision. Rule 1.5 talks about it requires the lawyer to keep the client reasonably informed about the status of the matter, but ethics opinion in states differ, right? It differs whether a lawyer is obligated to inform the client that he or she is leaving. But there's no prohibition against the departing lawyer to say, telling the client, hey, I intend to leave. But the nature of that communication has to be one that is neutral. It can't be, hey, I'm intending to leave. I'm going to this firm. Please come with me. So Rule 7.3 prohibits a lawyer from soliciting a prospective client either in person or by phone, but it makes an exception when there's a prior relationship. 7.3 and 7.1, communications by a departing lawyer may not be misleading or overreaching, what I just talked about. The communication should urge the client to sever should not urge the client to sever a relationship with the original firm or even disparage the original firm, because again, it's up to the client. The requirement of the Rule 0.73, the written communication to the prospective client should be labeled as advertising material, does not apply here. However, the communication must be neutral and it must be merely a notification that the departing lawyer is leaving to satisfy his professional obligation. And it can provide the new employment, and it can provide the lawyer's new address. But that is as far as it can go. You cannot solicit the client to come with you. Emails, the thorn in my side of existence. This involves sending client personal information over the email system. And all I would say with this one, you have to be very, very careful, because once you fire off that email, you can't control where that email is going to end up. And this just says exactly that. Sometimes you send emails to one person, and then that person puts another person on the email, and then that email is forwarded, and before you know it, it's 12 people on an email regarding your client. So this case, a law firm maintained a website that contained a link allowing visitors to send emails to the lawyers at the firm, but the site contained no warning or disclaimer regarding the confidentiality of the information sent. So when a company, and again, I changed the name, called ABC Corp, sent an email to one of the firm's lawyers regarding a possible legal action against XYZ Corp, the firm suddenly faced an ethical dilemma because it represented XYZ on another matter. The firm sought advice from the Bar Association Professional Ethics Committee. First, because the firm failed to provide the necessary disclaimers that we talked about in the previous slide. The committee said the lawyer who received the email must maintain confidentiality because perhaps they had fallen into that attorney-client relationship. And secondly, the firm could not continue representing XYZ because now you have an ethical dilemma if ABC confidential information materially limited its ability to represent XYZ. And again, this was a marketing tool that was used to help attract clients, but nonetheless, without the proper disclosure, disclaimers, whatever you want to call it, it was deemed a problem. These are some tips about email. One way to protect attorney-client privilege is to put that in the label, attorney-client privilege, in the subject line. Of course, most of us just automatically do that, but again, courts will look at what did you intend to do. It's way too easy to hit forward and let a whole gang of people know. Again, you can't control who that email is subsequently forwarded to. You maintain your obligation of confidentiality. So sharing emails with client representatives who need to know on a need-to-know basis is probably the best standard. Watch where your privileged messages are going. Make sure your clients know who their privileged messages are going. There's no hard and fast rule about keeping emails. There's no hard and fast rule about email destruction, but nonetheless, it's important that you have what we call a litigation hold letter. But when litigation is credibly threatened, a hold must be issued, and any deletion of emails must stop. It is up to lawyers to warn clients when this must occur. The consequences of post-threat destruction can be very severe, both on a client and the lawyer. And again, Louisiana has issued an ethics opinion that I cited down here. A lawyer must consider the benefits and risk associated with using technology and representing a client. When a lawyer uses technology in representing a client, the lawyer must use reasonable care to protect client information and to assure that the data is reasonably secured and accessible by the lawyer. Again, the burden is put on a lawyer. If you're going to use this technology, the burden is on you to prove that you took reasonable care to maintain that attorney-client privilege and to maintain the protection of that client's confidential information. The duty to communicate is essential to every aspect of your fiduciary responsibility that you owe to your clients. The duty assures that the client interests are properly identified and well served by the lawyer. Remember to initiate communication on 6 key occasions. And I agree with all 6 of these. As a rule of thumb, this is when it's time for you to communicate with your clients. You can decide whether or not you want to put it in writing or a telephone call, but these are 6 things that I think triggers a response from you that you should directly communicate with your client. And I put up here the trap: failing to communicate with clients, the way out, do more than just return phone calls. In addition to returning phone calls, if these things come up, you should automatically have a formal communication with your client. When decisions require client consent about the objectives of representation, such as the decision to settle or appeal, that is a client decision, not an attorney decision. When seeking any waiver of the client fiduciary obligation, especially confidentiality and conflict of interest, I would include of matters of medical disclosure, employment disclosure, or any kind of financial disclosure. Those are direct conversations that you should have with your client. When decisions require client consent about the means to be used to accomplish the client's objectives, such as agreeing to litigate, agreeing to arbitrate or mediate a matter, or whether or not to stipulate to a certain set of facts. Again, those are all things that as lawyers, we can offer advice to and direction to, but ultimately that decision, that communication has to be formally with the client. When clients should be updated on the status of a matter, especially about the development in the representation of itself, such as a judgment is rendered or a motion has been granted or denied, or that there's an illness of the lawyer, or again, as we mentioned, the lawyer is either merging a law firm or leaving a law firm. Those direct communications should be had with the client. The big one, number 5, when the client requests information, we should always give the client whatever they requested if it's reasonably within our scope of representation. If the client requests their file, if the client requests something that's related to the representation, we should make sure the client gets it. And when the client expects assistance that the lawyer cannot provide, such as a counseling committing a crime, we should tell our clients, I cannot do that. That is illegal. That is the extent of my representation. So when these 6 things happen, it's key that you initiate communications with your client, and it's more than just return a phone call. Doing business with clients, in a nutshell, it's a hectic thing to do. It's on shaky ground when you do business with a client. And I'm not saying do business with a client as in the client hired you to represent them. That's the initial relationship that you had with the client. I'm talking about entering into agreements, other transactions outside of the representation. So it says a lawyer fiduciary duty to the client is so essential to the relationship that the lawyer doing business with a client is held to a higher standard of conduct than anyone else. Rule 1.88 of the model rules, for instance, imposes strict disclosure requirements on a lawyer who engages in a business transaction with a client. And again, this is outside of the representation. This is a business transaction. And it said, first, the terms of the transaction must be fair and reasonable to the client. The lawyer must explain all aspects in writing in a way that it is reasonably comprehensible to the client. Second, the lawyer must inform the client in writing that they should seek their own lawyer about the transaction, this particular transaction, and give the client a reasonable opportunity to do so. And the final thing, the client must sign an informed consent to the transaction, disclosing that the lawyer is representing the client in the deal. So it's just to put everything in writing that the client understands, I am no longer representing you. We're doing business in a contract relationship. And that is not a continued part of the representation that we originally agreed upon. I put this here for Louisiana, how to seek ethics opinion and access the ethics opinions that I had in my PowerPoint. Louisiana employs a staff at the state bar that's headed up by Eric Barrefield. They get back within to you about a week. You present them with a question and they provide you with an answer. It's not open to the public. It's only open to members of the bar. They will either point you to a current ethics opinion that they've already produced, or they will produce one for you based on the factual scenario that you laid out. So I just put that up there. I've used it once. I'll give you an example. When I was in the military, I was given some emails from a commander, and I'm not sure how the individual came to have those emails. They weren't stolen. Someone gave them to him. And I attempted to introduce the emails in a trial to prove that there was some prejudice in the decision-making. And I was threatened with a bar complaint because the emails were not given to me, or I was not authorized to have the emails. And I asked the ethics council to provide me with an opinion, and they provided me with a very, very thorough opinion. It basically says, as long as those emails were not obtained by illegal operation, or basically they weren't stolen or hacked, that they were fair game. So including in my motion to include, that was in opposition to the motion in limine by the prosecution, I attached that ethics opinion in addition to the case law that we had. And so I've used the ethics service myself regarding an issue that I've had with a legal matter. So they're very helpful. Like I said, they normally get back to you in a week or so, but that's the information on the website. So now we've reached the point of questions, comments, and concerns. That's my contact information. I'm always open to talk to people, to talk about ideas and how we can get better and how we can avoid those ethical traps and successfully practice law, if you would say, and continue to practice law without having a call from those folks out at the Office of Disciplinary Counsel. Marla?
Hello, if anyone has any questions, you can either pose it in the chat, or if you wanna, you can also pose questions anonymously if you want to by using the Q&A function. If you have any questions for Assistant Secretary Walker pertaining to either the presentation or just something that you may have a question about pertaining to ethics. Assistant Secretary Walker, I think that you've done such a wonderful job. Everyone is fully satiated in the area of ethics for attorneys.
Well, everybody have a socially distanced, mask, face shield wearing Halloween. I hope you enjoy your weekend. Wear a costume. Don't be like me and buy a costume and they can't put it on. So that's all I have.
I do have one question. And we've discussed this briefly in the past. You know, my area that I deal with is cannabis. And we know that cannabis is federally illegal. And we have quite a few people who are getting involved, whether they're dealing with people who may be a medicinal patient, or maybe they have some clients who are employers of people who are medicinal patients. What do you foresee as ethical concerns for attorneys who want to get into this area of cannabis, or advising clients when it comes to cannabis advisement?
Well, I think the biggest thing that I always cringe is I do not think most lawyers understand that cannabis is federally illegal. And I think that before you start advising anyone about operation, business, banking, or anything associated with the cannabis industry, you need to understand the difference between what's legal federally and what's legally, or what has been put in operation in the states. Secondly, the transactional work, right? That federally insured banks can't handle cannabis transactions. And that you are under ethical obligation to have your client understand the potential legal exposure that they may have if they don't operate within the state confined rules and what the federal government has refused to do, or the rules that they have laid out. So that's the two biggest things that I would say that lawyers have an ethical obligation to tell their clients in the cannabis space about. First of all, the lawyer has an ethical obligation to educate themselves regarding the cannabis space, which I think a lot of that doesn't go on. And secondly, they have an ethical obligation to advise their clients that if you're not careful in what you're doing, you may inadvertently commit a federal crime, particularly in the banking and operational world.
Thank you. And also make sure that they advise them that they're operating in a federally illegal space. Any other questions for Assistant Secretary Walker? I always like to pose the cannabis question to people because I know a lot of folks are starting to engage in this in some way, shape, or form, and I think that everyone needs to be fully aware of the ethical responsibilities they have before they start to engage in this.
And I would say it. Again, I'm not an expert at anything, but I did sit in the general counsel's office for 2 years, and everyone knows Southern has its cannabis program. And Maul is absolutely right. There's a lot of tentacles. There's a lot of misinformation. There's a lot of regulatory stuff. And that's just a misunderstanding of where you what you can and cannot do, your left and right limits, and that federal obligation that still makes this thing illegal. And folks are offering advice, standard advice that would be good in any other circumstance or any other business transaction, that they do not take in holistically the rules in place, the federal regulations in place that involves cannabis.
All right, so if no one else has any other questions, I want to thank you all for participating in this installment of Becoming Fierce in the Practice of Law. Next week, we will have Becoming Fierce in the Practice of Law, the Personal Wellness Edition, which I think that is it's very, very timely, given the fact that we have been under quarantine circumstances for the majority of the year. And sometimes boundaries with work and personal life cross, and finding out how we can actually deal with that and handle that. So hopefully you all will join us next week for Becoming Fierce in the Practice of Law, Personal Wellness Edition. Also, if anyone has any issues with login, I usually get a barrage of emails right at noon or phone calls. And when I say barrage, it's only like maybe 4 or 5 people, but they all come in at one time. But so if you have any questions with login, because this is a platform that we have purchased to make sure that